Cool. Yeah. Thanks for having me. So yeah, I'm Justin Sanders. I'm a patent attorney, the intellectual property attorney, but also registered patent attorney. Yeah, I work primarily with startups and small businesses, helping them identify what intellectual property they have, and then also help them protect it and monetize it and enforce it to some degree as well. Today we'll talk about just kind of patent basics, general patent overview, including things like the timeline, step-by-step process, typical costs involved, and all that fun stuff. And I will, if anyone's interested, I can distribute the slide deck after the presentation. I can either send it to you, Travis, or people can just email me directly if they want it. Either way works. But
Yeah,
um,
please send it to me, and then if anybody, and I'll send it out to everybody who registered, and if anybody else wants it, they can just reach out to me.
Yeah,
Make it easier.
perfect. Yeah. So that way you don't have to, no one has to try to jot down notes or anything. And the slides do cover quite a bit of information. I mean, just depending on time, how things go, I might skip over some things, but also at any point, feel free to just chime in if you have any questions. I mean, there's a small group here, so just feel free to unmute yourself and ask a question at any point, or you could type it in the chat. Either way, but yeah, happy to answer questions at any point about any topic. I mean, probably about patents, but if you have any other questions, just feel free to ask, and we'll just kind of yeah, go with the flow on this one. So yeah, we'll start with some patent basics. Just kind of give you some general foundational knowledge. Again, we'll talk about the typical way that this patent process goes, typical costs involved, things like that. I'll also touch on some things like patent searching, because a lot of times when I'm working with startups, in particular, with the shoestring budget and everything, a lot of times they want to do some of the legwork themselves. So I'll just kind of touch on, like, if you want to try to do your own initial patent search, just some tips on that. Same thing with actually filing a provisional application, which we'll get into what that is a little bit. But just some general tips, things to keep in mind if you're going to try to tackle that process on your own to try to save a little money. And we'll talk about some other just patent considerations, other issues that are kind of related to patents that you have to keep in mind, like ownership issues and things like that. So but yeah, if at any point you have questions, just feel free to unmute yourself and chime in. So as you might know, I mean, there's four main types of intellectual property. Again, tonight's talk is focusing on patents, but just so you have the kind of the general background, when we talk about patents, that's what's used to protect inventions, products, unique services sometimes, but products, processes, things like that, unique inventions. Trademarks is the vehicle that's used to protect what we call the source identifiers that you actually place on these products or services when you take them to market. So that's, you protect those brand names, taglines, logos, et cetera, as trademarks. Copyrights are what we use to protect what we call creative expressions, photos, music, books, any kind of creative expression that's typically protected through copyright. And then trade secrets is what we use to protect confidential information, like the Coca-Cola recipe, or even things like standard operating procedures within your business, proprietary algorithms, customer lists, things like that, and any confidential information that's protected through as a trade secret. And so again, tonight's talk is going to be focused on the first one, patents, which is again what we use to protect inventions. Any unique technology might develop, a unique product, process, etc. And we'll get into the different types of things that could be patented in a little bit here. So in short, a patent is basically a set of exclusive rights in an invention that's granted by a particular country for a limited period of time. So it's this limited monopoly, basically. And so the way it works is you file this patent application that kind of teaches how to make and use the invention. It's this ultimately this public disclosure, this public teaching of what it is you've developed, how to make it, how to use it, etc. And if that invention is sufficiently unique, then you get a patent that gives you exclusive rights for a limited period of time. So it's the whole patent system is there to encourage the disclosure and the sharing of information, because in doing that, you're furthering innovation, where you're sharing how to make and use this great thing, and then the public is able to learn from that. And once your patent
Oh, Justin, you accidentally muted yourself.
there we go. Sorry about that. I'm not sure how that happened, but um, so um, so it's basically you're disclosing to the public, here's how to make and use this great thing, and then once your patent expires, and the public at large can then improve upon that, make the next best version, etc. And so to encourage that sharing of information, these patent systems were put into place. And so what a patent gives you basically is the right to exclude or prevent others from making, using, selling, offering for sale, or even importing infringing goods or services into whichever country where you have this patent protection. So this is something that's on a country by country basis. So like if you have a patent in the US, that US patent is going to give you these rights. So no one in the US can make, use, sell, offer for sale, or even import infringing products or services into the US. And the same type of protections can be attained in other countries as well. And so having this stuff properly protected, getting that exclusivity, is really what adds value to your business, particularly if you're early stage, if you're a startup, if you're pre-revenue. I mean, the only value you have sometimes is in this type of intellectual property, and particularly with patents. So like if you're trying to fundraise, trying to attract potential investors, or maybe even trying to set your business up for acquisition, going through these steps and protecting this whatever technology you're developing is really critical. I mean, sometimes, particularly when you're talking about fundraising, a lot of times you can't even get meetings with investors unless you can tell them that your technology is patent pending, meaning that you've filed that patent application, you've started the process. And so it's, and as we'll get into in a little bit, there's certain timelines you have to stick to in order to do this as well, meaning that if you wait too long, you could miss the window to actually get a patent on what it is you're developing. So this is a conversation you need to have early on as you're developing something new, definitely before you go public with it or before you take it to market. And I'll get into why in a minute on that. The important thing, though, to keep in mind is that you don't have to have a patent in order to take something to market. So it's not a grant of permission to go to market. It's not an admission ticket to now allow you to sell this product or service. It's just, if you want to have the ability to stop competitors from doing exactly what you're doing, or something that would come close enough to infringe your patent, then you have to go through this process. You have to get a patent in order to maintain that exclusivity and be the only one out there that's offering this product or service. So that's the benefit that a patent provides, is it gives you this, again, kind of basically a head start on your competitors, a 20-year head start, because that's how much time these utility patents will give you. And so that's the benefit, but it's not required if you want to just take something to market. It just gives you that competitive advantage. Another thing that's important to keep in mind, though, kind of the other side of the coin, is even if you're able to get a patent, that doesn't necessarily mean that you can take it to market. And what I mean by that is, oftentimes when you invent something, usually it's going to be not necessarily something that's completely brand new, but like a better version of something that's already out there. Or maybe you've combined existing components in a unique way, and it's unique enough to be deserving of a patent, and we'll talk a little more in a minute about that. But oftentimes these inventions, even if they are patentable, they're not necessarily completely brand new, and such that if you incorporate a component that someone else has previously patented, if that patent's still active and you take your kind of combination product to market without that patent owner's permission, you could be infringing that patent. And so, in other words, yes, you've come up with a unique combination of pre-existing components and unique enough to get your own patent, but that doesn't necessarily mean that you have what we call freedom to operate to take that to market. And so I mention that because it's just something to always keep in mind before you go to market with something. The two main considerations are, one, is my product unique enough to be patented? And separate, completely separate from that, two, if I take this product to market, am I going to infringe anybody else's patent or intellectual property rights? And so that's not something that you would be expected to know the answer to yourself, but just keep that question in mind and ask that question to an attorney before you take something to market. Because if you find something, or if an attorney finds something that you might be potentially infringing, it's a lot easier to modify your product before you go to market as opposed to after. Because if you take it to market and you get hit with a cease and desist letter, now you're possibly having to pay damages for a patent infringement claim. You're going to possibly have to recall or destroy products. You're going to have to redesign the products. And it's just a whole can of worms that you can avoid if you just do this type of research before you actually take a product to market. And so just remember that even if you're able to get a patent, doesn't mean that you have freedom to operate. That's a separate issue that we have to look into. So yeah, as I mentioned, these rights are country specific. And so it's just another conversation to have with an attorney as far as figuring out where you might want to file patents. There's no such thing as like a worldwide patent. This is all going to be country by country. And so usually the US is going to be the biggest market for most products and services. So that's typically where people are filing at the very least. And then beyond that, just like where your biggest market's going to be potentially. Maybe we look at secondary markets. Sometimes, depending on the product, you might look at countries where competitors might try to manufacture knockoffs. So like China, Mexico, places like that, depending on the industry and the product type. But again, I mean, that's something where you can have that conversation with an attorney and kind of prioritize, come up with a list of countries where you might be interested in filing, and then kind of just figure it out based on that, based on your budget and everything else. Because the reality is that even the biggest companies out there don't typically file patent applications in every single country around the world. Everyone prioritizes because this all costs money. It costs money to file the applications and obtain the rights. It costs money on the back end to maintain those rights, to enforce those rights. And so it's just a matter of being realistic about what's your budget, what's your priorities, and then based on that, just figuring out where it really makes sense for you to file these patent applications. But the nice thing is, and as we'll get into, you don't have to file all these applications all at the same time. So you can file in the US first, and then you have a period of time before you have to follow up and file these international applications or these non-US applications. So as far as what can be patented, I mean, it's basically anything as long as it's something that you truly invented. And so you see the list here. It could be things like processes, so a method of making something, a method of using something. It could be a process. It would also be like a software algorithm. It could be machines or articles of manufacture, so like a hard good, if you will. Compositions of matter, so if you develop some new chemical composition or new pharmaceutical, things like that, that's all potentially patentable. And any improvements on those things. So again, I mean, it's very rare for someone to come up with something completely brand new. Most of the time, it's just a unique combination of existing components or just a better version of something that's already existing. And so if those improvements are sufficiently unique, that's also potentially patentable. So, I mean, the short list of what's not patentable, it's kind of common sense things. I mean, things like laws of nature, natural phenomena, things that you might discover but not invent. So patents are reserved for inventions, not discoveries. And then the other one, which we won't really get into just for interest of time, abstract ideas. This is something that really comes into play when, particularly if you're developing software. And so, I mean, I could give a whole talk just on this issue of what we call subject matter eligibility, and it's really something that we could discuss specifically your case with an attorney. I'd be happy to have the conversation with you offline as far as whether, if you are developing software, whether it's potentially patentable subject matter. But I mean, ultimately what it boils down to, and this, just like any other area of law, this all just depends on what the courts currently think about a particular issue. And so, and right now, the Supreme Court has kind of laid down the rules to say that not all software is patent eligible. But if you want to patent software, what they're looking for, what the patent office and what the courts are looking for, is they want to see if the software is, as they're right here, specific technical advance over the prior art. So they want to see technical solutions to technical problems, like if you developed a new like data encryption algorithm or some new communication protocol, something that basically improves the computer in some way, how it performs, enables the computer to do something it previously was not able to do. So like a lot of artificial intelligence type algorithms, now this computer is able to autonomously do things that it previously was not able to do. Things like that are still what we call patent eligible or potentially patentable subject matter. Things that would not be would be things where the computer is essentially just acting as a tool rather than necessarily being improved upon. So like if I develop an app that calculates interest rates, or some new calendaring app that, I don't know, harmonizes multiple calendars together or something like that, where, I mean, it's mainly just the computer acting as a tool rather than the computer necessarily being improved upon. And again, that's something that you can discuss with an attorney, and they can provide you with more guidance as far as whether your particular piece of software is potentially patentable. But the takeaway is generally that software is still patentable. You might come across articles that say to the contrary, but it is still possible. I get software patents all the time for my clients, but it does come down to what that software entails. Are there enough technical details in that software to kind of satisfy these rules? So just, if you are thinking about trying to patent software, just keep that in mind, that it's got to be technical enough in nature as far as whatever problems that software has been designed to solve. And so beyond that threshold issue, I mean, ultimately what it comes down to is your invention has to be sufficiently unique compared to what we call the prior art. So prior art being that anything out there publicly accessible that was out there prior to your application filing date. So in other words, like if I filed my patent application today, anything that was out there as of yesterday online in published patent applications or patents, a YouTube video, a product that's on the market, a academic publication, anything that's out there that was publicly accessible prior to today, my application filing date, counts as part of this universe of prior art. And so let me see. So that's just something to keep in mind is when we file, and that's why sometimes you'll hear that the earlier you file your patent application, the better. That's part of the reason why, is because the sooner you get an application filing date, the sooner you're cutting off that universe of prior art. And we'll get into a little more of that in a minute. And just one other thing, you don't have to have a working prototype. So if you're still developing your product or your invention, you don't necessarily have to wait until you have a working prototype before you start this patent process. If you have enough of it figured out in your mind, you kind of know generally how it's going to work, what components are going to go into it, etc. You can file a patent application at that point rather than waiting till you have that working prototype. But I mean, obviously, the further along or the closer you are to having a working prototype, particularly one that's like ready to go to market, in theory, that the more hurdles you've overcome to get to that point, and the further developed the product is, so that you might have additional details to put into an application as compared to if it's still more of just a general concept. And so as far as the timing of when to file, again, that's something you can discuss with an attorney. They can tell you whether it's too early to file or whether you've got enough details to go ahead and move forward. But just know you don't have to sit on something and wait to have that conversation until you have that prototype. You can start having these conversations a lot earlier. So I kind of alluded to this earlier, but one of the big issues when it comes to patents is what we call public disclosure. And this probably or one of maybe two or three, I would say the most important points that I'm going to make during this presentation is this public disclosure rule, because this could make or break your ability to pursue patents. And so public disclosure under the rules is basically any disclosure that's not covered by a non-disclosure agreement or confidentiality agreement, meaning that if you show this to somebody and they have not signed an NDA, it's considered a public disclosure. So it could be like a public use or public display. So if you're just testing your device out there in the open, it could be a public or private sale or offer for sale, or even just a public commercial exploitation of the invention. What I mean by that is, let's say that, again, if you're in the software world, if you make your software available for download, what you're typically going to patent in software are the underlying algorithms. Those algorithms are not going to be visible to the end user, but the fact that you're commercializing the software, that counts as public disclosure of those algorithms. And so where this all comes into play is that if you do publicly disclose in some way before you file your application, you still have a 1-year grace period in the US where you could still file your patent application as long as you file it within 1 year from that date of first public disclosure. Outside the US, though, you're out of luck. So in other words, the rule in other countries is that you have to file your first patent application before any public disclosure of your invention takes place. And so if you publicly disclose even a day before you file your first patent application, your own public disclosure counts as part of that universe of prior art. And the same is true in the US if you wait longer than a year. So if you, let's say, publicly disclose today, and then you wait a year and a day before you file your patent application in the US, your own public disclosure activities count as prior art against your invention, meaning that you are no longer able to get a patent on that invention because you publicly disclosed it more than a year ago. And again, that's the rule in the US. Outside the US, you have to file before any public disclosure takes place. And again, as I'll get into, there's ways to kind of string these applications along. So the key is that you have to get your US application filed before any public disclosure if you want to keep all of your options open. I mean, hypothetically, if you come to the decision that, you know what, I'm not interested in filing patents outside the US, I only want to focus on the US, well then, okay, I mean, you've made the decision. You can go ahead and publicly disclose before you file your patent application, but at least even in that scenario, you're making the decision rather than the decision being made for you by virtue of just publicly disclosing before thinking about these issues. And so just the thing to keep in mind is that you want to keep these inventions confidential until they're patent pending, meaning you've got a patent application on file, at least in the US. And if you have to disclose to someone in the meantime, let's say that you are talking to potential manufacturers, maybe you have to talk to software developers to help you actually implement your concept. Just have these entities sign a non-disclosure agreement, and then anything you disclose to them is not considered a public disclosure. That would be a confidential or a private disclosure. So you're not triggering these issues or these deadlines. So just keep that in mind. I mean, just keep things confidential. Have people sign NDAs. I mean, disclose things on a need-to-know basis, even in addition to having people sign NDAs. And then just think about filing an application sooner rather than later, or start having that conversation so that you can make that decision, whether it's even worth pursuing a patent on. So there's 3 types of patents that you can get in the US and in other countries as well. But the 2 main ones are utility and design. We won't even talk about plant patents because that's a whole different animal if you're developing plants or seeds and things of that nature. But what most people, when they think about patents, what they're usually thinking of is a utility patent. And then there's also design patents. But utility patents essentially protect the structural or the functional features of an invention. In other words, the way an invention works. And then you get about 20 years of protection when you obtain a utility patent. And then design patents, on the other hand, rather than protecting how something functions, it just protects the way something looks. So if you have a product that has a unique look to it, some aesthetic appearance that's unique enough, you can get a design patent that protects that look. And then with design patents, you get a slightly shorter term. You get 15 years rather than 20. And it's definitely possible to get both utility and design patents on a particular invention. So like, for example, the original iPhone, Apple got a design patent on the way the iPhone looks, kind of that basic rectangular shape with all screen and a center button. So they got a design patent on that look of their phone, but then they also got utility patents on some of the underlying functionality, the hardware, the software, et cetera. And so this is all going to be case by case, but just something to keep in mind as you're developing whatever it is you're working on. You might be able to get utility and design, maybe one or the other. Sometimes something has a unique look, but the functionality isn't unique enough to be patentable from a utility patent perspective. So again, not something that you would need to know yourself, but just a conversation to have with an attorney to figure out, okay, what is potentially patentable, and how, what's the best strategy for my particular product or process. And again, there are similar types of patents in other countries. So on the utility patent side, as I mentioned earlier, there's what's called a provisional application, and some of you might already be familiar with provisional and non-provisional. We'll just kind of talk about them briefly. But so you've got two types: provisional and then non-provisional applications. And so a provisional application is kind of a starting point. If you're still kind of early in the development, or you can't afford to jump right into a full non-provisional application, you can file a provisional as a first step. And what this provisional does, it's not examined. It's not going to turn into an actual issued patent. It's literally just an invention disclosure that you file with the patent office, and essentially kind of holds your place in line. So if I file my provisional application today, I get a filing date of September 13th, 2023. And then what's expected of me is within that year, or I should say within a year from filing the provisional, I'm following up and filing that non-provisional application, because it's the non-provisional application that would ultimately get examined. And if it's deemed unique enough, then that non-provisional would issue as a utility patent. And so the benefit, though, is if you do start with a provisional, as I said, it holds your place in line. So if I file a provisional first and then I later file the non-provisional within a year's time, that non-provisional will be backdated and given the same filing date as my provisional. So again, if I file provisional today, and then on September 13th, 2024, I file my non-provisional, that non-provisional is going to be given a filing date of September 13th, 2023, rather than 2024. And the main benefit there is, again, as I mentioned, the universe of prior art that can be taken into consideration in determining whether what you've come up with is sufficiently unique, gets cut off as of your earliest filing date. So if I basically can cut off the universe of prior art today by filing a provisional, even if I wait another year before I file like my full utility patent application. So, and I'll get into a little more about that provisional in a little bit, but that's the main benefit of starting with a provisional. But you don't have to. You can jump right into the non-provisional if you want. And again, we'll get into some of the reasons in a little bit. And so then beyond that US filing, I mainly just have this just for your information in the slide deck, just to kind of keep it complete. But there's what's called a PCT application that can be filed that kind of holds your place in line on the international level. And so the way it typically works then, is, as far as the timeline goes, is, I mean, first and foremost, usually you want to do some kind of patent search. At least most people do. It's not required. You're not required to go out actively looking for prior art that could be taken into consideration by the patent office. But a lot of times my startup clients, they do want to do some kind of searching because they don't want to spend the time and money filing an application if it's not going to go anywhere. They rather use that money elsewhere in their business, just getting the product to market, maybe protecting their trademarks, et cetera. I mean, there's always ways that money can be spent, and sometimes patents aren't the best focus or the best use of that money. And so they'll oftentimes want to do some kind of patent search to see how unique is this invention. And so that's typically step one. And again, that's something you could potentially do on your own to some degree, and I'll get into some of those details in a little bit. Beyond that, though, if you come to the conclusion that there is something unique in your invention and worth pursuing, or if you just want to file and see how it goes, then you would file your U.S. application. Again, you can either start it as a provisional, or you can jump right into a non-provisional. So if you start with a provisional, within a year's time, you got to file that non-provisional. And then ultimately, once you file that non-provisional, it takes about 1 to 3 years before you actually hear or receive like a response on the merits from the patent office. So in other words, you file this non-provisional application. It sits in the patent office for a little bit. They first check it to make sure that you've provided all the necessary components, written description, claims, drawings, what's called declarations from the inventors, things like that. They make sure all the right components are in there. If anything's missing, they let you know, and then you provide it at that point. Once it passes those formality checks, it gets routed to a particular what's called an art unit within the patent office. And so the patent office is broken up into all these different art units, with each art unit kind of being focused on a particular field of technology. So like, for example, there's an art unit that focuses on software. There's an art unit that focuses on pharmaceuticals, on hard goods, on medical devices. And so within each of these art units, there's examiners that have that requisite background. So the way it works in it, if I file a patent application on a medical device, ultimately it's going to be given to an examiner that has some kind of medical device background. Oftentimes they have a degree in, let's say, mechanical engineering or some kind of medical degree in that situation. If it's a software-based application, it's going to go to an examiner, probably with a degree in computer science. And so they're not completely out of the loop when it comes to your invention. They have some familiarity with the technology, and so with that background knowledge, and with the application in front of them, then they perform a patent search, basically a search of all these prior art sources. So primarily they're looking at patent databases. So like the US has a patent database. Every country has their own patent database that includes all applications and issued patents for that particular country. They also search what's called non-patent literature sources. So again, like academic publications, just general internet searches. So basically they look at your application, particularly the claims portion of an application, and then they go out searching to see if they can find anything that comes close to what you're trying to claim or what you're trying to get a patent on. And so that whole process then is like the 1 to 3 year wait time. That's kind of what's happening behind the scenes. Now there's what's called prioritized examination, where basically you pay an extra fee to the patent office, and then they will fast track your application. So instead of waiting like 18 to 24 months, you'd only be waiting like 3 to 4 months if you pay for the fast track option. And so with that said, like as far as costs go, The official filing fees, I'm guessing most of you would qualify as what's called a micro entity. So basically, a small business or a solo inventor, where like this is your first application or one of your first few applications, and you've made less than like $250,000 last year pre-tax. And I've got all that in a later slide. But if you qualify as a micro entity, the filing fees that you pay to the patent office, currently it's like $364 for a provisional application. For a non-provisional, it's like $664. If you want to pay for that fast track option, that currently costs for a micro entity, it's like about $884. So I mean, if you were to file a non-provisional and request prioritized examination, I mean, you're only gonna be paying about $1,200 or so, $1,200 to $1,400. And then, I mean, that's the official fees. As far as what you'd have to pay your attorney, I mean, that's where it can vary pretty widely. I mean, depending on how big of a firm you're using, and all that. And so, I mean, I could tell you, like, for like what I typically charge, it's usually like anywhere from like 5 to 7,000 to do like a full non-provisional, in addition to those filing fees. If it's like a provisional, I usually just work within the client's budget, so I could do things for as little as like $300 to $500 plus filing fees. But I mean, some attorneys or some law firms might charge 20 to 30,000. I mean, it depends, and that's why, I mean, one of the conversations you have with an attorney before you hire one is you want to figure out like what kind of costs would you be looking at if you were to use them, and so you can kind of budget accordingly. But so yeah, I mean, to do it right, to do like a full utility application, when you include attorney's fees plus filing fees, those initial costs are going to be, I would say, about 6 to 8,000 in most cases. I mean, if it's a simpler invention, it could be a lot less than that. If it's a more complicated invention, it could be a little more than that. And so that's just, it's going to vary from case by case, from case to case. But that would be kind of the general initial cost you would be looking at. And so then once it gets picked up for examination, again, the examiner is going to search that prior art. If they find things that come close, they might reject one or more of the claims in your application, and that's what they issue what's called an office action. And so in that office action, let's say you've got 20 claims in your patent, they might say claims 1 through 5 are rejected because they're what we call anticipated, or they're obvious in light of these prior art references. And then maybe they say that claims 6 through 10 contain allowable subject matter. And so they basically go claim by claim and say, okay, this one is not allowable, this one is, etc. And that's all put into this written office action that we receive. And if we disagree with any of the examiner's positions, we have the opportunity to respond back. We can amend the claims. We can submit arguments back, because a lot of times these examiners don't quite understand the invention. And so it's just a matter of kind of more clearly explaining things to them. And usually we can find some common ground where we can get the case allowed. But once all the claims are in condition for allowance, whether we amend the claims or cancel out the rejected ones, eventually you would receive what's called the notice of allowance. So once all the claims in the application are allowable, the patent office would say, okay, this case is allowable. You receive this notice of allowance, and then the last step at that point is you pay what's called an issue fee, which it's I think for a micro entity, it's like just under $300. And then again, there's probably going to be an attorney fee in addition to that. So maybe call it like $700 total or so, for that issue fee step. Depending on if you do get office actions, there could be costs involved in those responses as well. And then after you pay that issue fee, though, a few weeks after that, you get your U.S. patent mailed to you. And then the only additional fees beyond that is what we call these maintenance fees. So there's three that are due over the course of the patent's life, and they're due by the fourth, eighth, and 12th anniversaries measured from that patent issue date. And so it's like for microentity, it's like I think it's around a few $100s for that first one, and then it gets, I think, up to like $800, and then like $1,200 for those fourth, eighth, and 12th year maintenance fees. And it's just, if you want to keep the patent active and enforced, then you pay those. If you decide, you know what, this patent isn't worth anything to me anymore, you just don't pay one of those maintenance fees, and then the patent would just kind of naturally expire. It would go abandoned, basically. So it's just, if you want to keep the patent active, you pay those fees. And so as far as like total cost, then, I mean, from cradle to grave, from application filing to U.S. patent grant, again, it's going to vary widely depending on who you use to help you with this process. But at least for my clients, they pay anywhere from like maybe 10 to 15,000 total on average. I mean, sometimes it's a lot less than that, sometimes it's a little more than that, but that's kind of the general ballpark as far as the total costs involved. And again, you've got like an initial outlay of, let's say, 6 to 8,000, possibly less, and then you've got typically at least a couple years to start budgeting for any additional costs. So it's not like you're paying this all up front. And I mean, depending on what attorney you use, you might be able to do like a partial payment and then pay the rest in installments. I mean, again, that's one of the reasons why it's good to talk to a few attorneys, figure out who's the best fit for you, who's going to fit within your budget and all that before you actually start down this path. But yeah, I mean, that's the general cost. And so beyond the U.S. filing, again, you have the option to pursue patents in other countries as well. And particularly what you do is you file this PCT application. So the way it works is a year after you file your U.S. application, whether it's a provisional or non-provisional, within a year from that filing date, you file a PCT application. And that's going to hold your place in line internationally for up to 30 or 31 months measured from your U.S. application filing date. So in other words, you file in the U.S. and then you have about 2.5 years before you have to file any non-U.S. applications. As long as within a year from the U.S. filing, you file that PCT application. Now, I'm sure this is getting confusing, and I mean, the good news is that these are deadlines that if you're working with an attorney, the attorney's keeping track of all this stuff for you. So you don't have to keep all this straight in your head. Like when I'm filing a U.S. application, roughly 6 to 7 months down the road, I'm sending reminders to my client to say, hey, we've got this international deadline coming up. Let's figure this out. Let's see if this is something you want to do. If they do want to move forward, we file the PCT application for them. And then when we get close to this, what we call the national stage filing deadlines, again, I'm sending reminders and saying, hey, which countries are you interested in? Let's start pulling cost estimates together. Let's figure out which countries are worth pursuing. And then whatever ones they decide to pursue, we're handling the filing of all that. So in other words, you're not the one, you're likely not going to be the one to actually file any of these applications. But just keep the timeline in mind as far as for your own budgeting purposes. Yeah, I mean, your attorney will also help remind you about these deadlines as well. So nothing falls through the cracks.
Hey, Jason, I got a quick question. I'm sorry.
Yeah.
Or Justin, I'm sorry.
No worries.
So what happens after a patent expires? Does it just fall off? Is it possible to renew them or keep them being renewed?
Yeah, it's a good question. And so, I mean, if you pay all those maintenance fees, the longest term of your patent is going to be 20 years, and technically that's going to be measured from your earliest application filing date. So in other words, you don't get 20 years from the date that your patent issues. So again, you might file this application, it might not issue for like 3 years after you actually filed it. The 20 years is measured from your filing date, not from your grant date. So, I mean, the way it typically works out is you get roughly like 17 years of enforceable rights once that patent issues, but technically it's measured from your filing date. So if you pay all those maintenance fees, your patent would naturally expire 20 years from your earliest filing date. Once that patent expires, it's essentially public domain at that point. And so, and the same is true if you let your patent lapse for failure to pay one of those maintenance fees. Now, if you forget to pay one of those maintenance fees, if it just falls through the cracks, and so in other words, if the application or if the patent goes unintentionally abandoned, you can pay a fee to revive it, to basically reinstate it, and then it kind of continues on that lifespan. But on the other hand, if you decide, you know what, I don't want to pay this maintenance fee because I just not interested, or I can't afford it. In other words, if you intentionally decide not to pay a maintenance fee, you cannot revive a patent in those scenarios. So it's only if it just somehow falls through the cracks. If you didn't mean to let it go abandoned, but it did, then you can revive it. But there's no way to extend it beyond that 20-year term. Yeah, it's public domain. So that's why you see, particularly like in the pharmaceutical space, like if someone has a patent on one of these pharmaceutical compositions, like the day after the patent expires, that's when you see all the generics hit the market, because then it's public domain at that point. And same goes for anything, but you see it most commonly in the pharmaceutical space as far as those knockoffs coming onto the scene. Because yeah, once that patent expires, you can't go after someone for patent infringement for anything that they sell after your patent expiration date. But yeah, just public domain at that point.
Thank you. And
Yeah.
so there's no way to get through this process, like compiling all the information first and then filing the first step. You need to wait and see what the response is before you can actually move on to the next step, correct?
Well, I mean, no, I mean, you can, well, I mean, I guess it depends on what steps you mean, but I mean, it's like usually what clients do is they'll file their patent application so that you're patent pending, and then they'll go to market. And so you don't have to wait to go to market until you have to get a until after you get the patent, because I mean, realistically, most people can't afford to sit around on an idea for 1 to 3 years. But the key is that you get that process started, because once you're patent pending, there's no public disclosure issues you have to worry about. I mean, technically, like if someone starts to make and sell knockoffs, you can't go after them. You can't sue them for patent infringement unless and until you have that issued patent in hand. And so for that reason, sometimes people still try to keep quiet on their idea while their application's pending. That's another reason why people oftentimes will opt to pay that extra fee to fast track their application, because then you can get a patent in as little as like 6 months sometimes, if everything goes smoothly, rather than having to wait 18 to 24 months. Because as soon as you get that patent, now you have something enforceable. But yeah, you don't necessarily have to wait to do anything after you file the application, though.
Got it. Thank you.
Yeah. So just in the interest of time, I mean, these, and again, you'll have these slides after the presentation, but if you're thinking like, should I start with a provisional or should I jump right into a non-provisional? These are the common reasons why you might consider starting with a provisional. Again, if you can't afford the full non-provisional, because the provisional you might be able to do yourself. A non-provisional application, I mean, it's just something you don't want to tackle yourself. I mean, you might be able to get a patent yourself, but I mean, it's in the situations I've handled where clients have come to me, they've already got their patent, they did it themselves, and now they want to go after someone for patent infringement. I'd say 9 times out of 10, I have to tell them that their claims of their patent are so narrow that this competitor's product does not actually infringe. And so, I mean, the value you get in working with a patent attorney is not just to get the patent, but get a broad patent, a patent that doesn't just cover your product, but all potential workarounds as well. And so that's the key. And again, that's where the cost come into play. And so if you can't afford to pay an attorney yet, you could start by filing a provisional, either yourself or with an attorney. Like I said, I can't speak for other attorneys, but I work within a client's budget. So if a client can only afford like $600, we'll see what we can do with that $600 to get something on file, because something's better than nothing. And I mean, still better to have an attorney help you rather than do it yourself to make sure it's all done properly. So that's a reason. Another reason to file a provisional first is if you're still developing the invention, if you're not ready to take that full utility patent step, you can file a provisional now on the details you currently have figured out, and then we can follow up in a year or less, whenever you're ready to do the full utility application and include any new details you developed in that interim period. Sometimes if you're about to imminently disclose the invention, let's say that next week you're going to be presenting as part of like a pitch competition, or let's say that you've got an imminent launch of your product plan and you can't push it back any further. That would be another situation where we can just rush file a provisional so that you're patent pending before that public disclosure takes place, and then we follow up with a non-provisional as soon as you're ready. Or if you're still deciding, like, you know what, I'm not sure if I even want to pursue a patent on this. I don't even know if there's going to be a market for this product. If you want to just at least keep your options open, you can file a provisional so that you don't cut off those options. So you're patent pending, then you can go test the market, see if it's actually worth taking the next step of filing that full utility application. And so again, something you can talk through with an attorney as far as which is the best option for your situation. But that's typically the questions that we ask our clients to kind of help come to that decision. So patent searching, again, not required, but it can be helpful if you do that searching, because it gives you a general idea as far as like how unique is your invention. Has someone else already come up with this idea before? And if so, then you save yourself the money. You don't file the patent application. You can focus that money elsewhere in your business. But again, you're not required to go out proactively looking for prior art. The only requirement that the patent office has is that if you do discover prior art, you legally have to disclose that prior art to the patent office when you file your utility patent application. So in other words, if you're aware of some prior art out there and you don't disclose it to the patent office when you file, that's considered committing fraud on the patent office, and that can be used later to actually invalidate your patent. So if you get a patent and let's say you sue somebody for patent infringement, if they are able to determine that you were aware of prior art that you failed to disclose to the patent office, they can use that to essentially cancel out your patent. And so it's a very serious issue. But again, it's only with respect to prior art that you're aware of. You don't have to go looking for it. And so if you want to do these searches on your own, the best what we call patent database or patent literature source is Google Patents. And here's the URL for it. And it works just like the normal Google search engine. You use just kind of plain English terms. It can be used to describe aspects of your invention. And then Google Patents will return any published patent applications or issued patents that use those same terms. So if you come up with good enough search terms, you could track down potentially relevant prior art. And the nice thing about Google Patents, I mean, aside from it being completely free, is it includes not just the US database, but a lot of international databases as well. So there's the PCT application. There's a whole database of PCT applications out there. Where, I mean, if anyone is going to pursue patents in multiple countries, usually they're filing a PCT application. That tends to be a very robust database. It also includes the European patent database, some, I think, Australia, China, and Japan, at least like where there's English abstracts and stuff in China and Japan, though I think a lot of them are machine translated as well, like the full publications. And so through this one search engine, you're able to search all these databases and find potentially relevant prior art to help you figure out if your invention is unique or not. And that's also a point where you can bring in an attorney to look at your results and help you come to that determination, whether it's something that's potentially patentable or not. And then in addition to that, to the patent literature, there's also non-patent literature sources. So just doing general internet searches through like the normal Google search engine or another search engine, looking through academic publications, e-commerce platforms, etc. I mean, anything that's out there is potentially fair game if it predates your application filing date. So yeah, I mean, these are all free resources that you can use to kind of do some of this searching on your own. If you want to have an attorney do the search for you, they definitely can. It's something I do often for my clients, but that's where there would be a cost involved. So again, I mean, for myself, usually I charge like a flat fee of $1,500 to do this type of patentability search for a client. But again, we can be creative with the scope of the search and things, so it could be less than that. But always good to use free tools, though, at least as a starting point to try to save yourself some money. In the interest of time, I'm not going to focus on this provisional stuff, but again, this will be in the slide deck. So if you wanted to try to tackle filing or preparing like a provisional application yourself, these are just like helpful things to include in your disclosure. I'm always happy to set up like a one-on-one meeting to talk more specifically about your situation and figure out a good strategy for you, and how to file and all that. And particularly if you want to tackle it yourself, I can give you some additional tips. So we'll just kind of skip over that and go to this issue of patent ownership. This is again one of those I would say public disclosure and patent ownership are probably one of probably the two big points in this presentation. And I mean, the takeaway here is you want to get all these agreements in writing. So in other words, if it's more than just you working on something, whether it's you and partners within your business, or if you're hiring employees or independent contractors, any of those situations, you want to have written agreements in place with all parties involved. Because the rule is that if you are working on something with other people, the default rule, if you don't have a written agreement in place, the default rule is that each of you as co-inventors are equal, undivided owners of that patent or of the underlying invention. And so in other words, let's say it's you and a friend that are developing some technology, and you co-own that technology, and a few months down the road you have a falling out, you go your separate ways. Now your ex-partner can spin off a competing business with the same exact technology and compete against you without having any kind of profit sharing obligations or anything else. And so in order to eliminate those scenarios, it's always advisable, particularly again if you're working with multiple people, to form some kind of company, whether it's an LLC as a starting point or a corporation. And then you basically have all this intellectual property owned by the company, by the business entity, rather than the individual partners or employees, et cetera. And so then in that scenario, if you have partners and you have a falling out with one of them, they exit the company, but they can't take the IP with them because the IP is owned by the company, not by the individuals. I mean, you'd probably still have to buy them out or whatever the operating agreement of the business states, but you don't have to worry about them taking that technology with them. And so definitely it's important to keep that in mind as you're working on stuff, and that's kind of more the partner level. But again, even if you have employees or independent contractors, you want to have agreements in writing that essentially state that employee or independent contractor agrees to assign, in other words, transfer their ownership interest over to you, the employer, or the company as the employer. And it's very basic language. It doesn't have to be anything complicated. The key is that it has to be in writing, because if it's not in writing, it kind of varies from state to state, from jurisdiction to jurisdiction. But some courts would conclude that if there's no written agreement, this employee or this independent contractor, as the creator of this invention, owns it, and you as the employer or the company has what's called shop rights, basically like a license to commercialize, but you don't own that intellectual property. And so those individuals can then do whatever else they want with it. They can separately commercialize it without your involvement or your permission, because you don't own that intellectual property. And so the way to eliminate all those issues, though, again, is to just get this stuff in writing, preferably at the outset, before you actually have someone start working on that project. So, and that's typically going to be the easiest time to negotiate the terms of these agreements as well, because usually in this type of agreement, you're not just going to talk about IP ownership, but probably confidentiality, where they have to agree to keep everything confidential. Payment terms, like how much are you expected to pay this individual for whatever they're creating for you. What are they creating for you? Are there certain milestones or deadlines by which they have to provide you with certain deliverables? I mean, putting all that into a written agreement just eliminates arguments or ambiguities down the road. And so it's really critical to get this stuff in writing. At the outset of the relationship. And you might be able to do like a Google search for like independent contractor agreement or invention independent contractor agreement or something like that to try to find something for free to use, or an attorney can help you prepare something. But and again, it doesn't have to be overly complicated or written in legalese or anything else. It's just you just have to have this stuff even just in plain English in a written document that's signed by both parties, or at least signed by the other side, just to eliminate these types of ownership issues. Because one of the first things, particularly if you're setting your company up for like acquisition, or even like a licensing deal, or even bringing on potential investors, they're going to do what's called due diligence, to make sure you're worth actually moving forward with in that type of relationship. And as part of that due diligence, one of the first questions they'll ask you is, do you have clean chain of title? And what that means is all of your intellectual property assets, all of your assets really, but particularly your intellectual property assets, do you have a paper trail going from the original creators of that IP all the way to you, the company, as the owner of that IP? And if there's gaps in that chain of title, that could at the very least pause the deal, or it could just completely destroy it. But if it pauses the deal, now you're having to scramble and go back and try to track these individuals down, try to get them to sign something after the fact, and it just be really messy and more headaches than it's worth oftentimes. But I mean, it's just, these are headaches that can be avoided if you get these things signed right at the outset, before anybody does any work. Yeah, so just remember that. And then just a last thing, just again, just kind of more of a reminder, we talked about this earlier. These patents are not a grant of permission to take your product to market. So even if you're able to get a patent, or if you decide not to pursue a patent, you still want to look into this issue of, do you have freedom to operate? Can you take this product or service to market without infringing anybody else's intellectual property rights? And again, that's something an attorney can help you with. You're not expected to come to those or up with the answers yourself. And we're focusing on patents in this particular talk, but I mean, freedom to operate could also apply to trademarks and other aspects of intellectual property. So even if you're in a situation where you don't have any proprietary technology, if you're just selling like commodity goods, you still want to make sure that the name that you're operating under is not going to infringe someone else's trademark rights. And so this freedom to operate conversation is always a good one to have before you launch a business or before you start to offer a particular product or service. Just make sure you're avoiding these potential issues. So yeah, that's all I have. Again, I'm happy to answer any other questions, either on patents or other areas of IP. And if no one has questions now, this is my contact info, my direct phone number, my email address. I'm always happy to answer questions by phone or email. I'm happy to schedule calls to talk through whatever you're working on, and just figure out the best strategy for your situation.
Well, thank you very much, Justin. Does anybody have any questions? And if you do, just please unmute yourself and ask away. JJ, how about you? You're unmuted. Do you have any questions?
I have actually, Travis, can I jump
Victor
in?
has
I
a
have a
question.
comment. I have a comment. Just a comment specifically in working with Justin and how much it helps to have an attorney knowing that you can move forward with your vision. So he's helping me on the trademark side of things. I'm making a organic chip, and had I not had an attorney helping me, I would have probably gone in 2 or 3 different directions that a year down the line I would have regretted. So just when I was starting in business, I was trying my best to just, penny pinch here and there. But this is an area where, looking back now, just the peace of mind you get is awesome. So just more of an endorsement of working with Justin.
Yeah,
Yep.
appreciate that. And yeah, I mean, it's definitely, and I mean, I'm cost conscious myself, like in my own business, and so like I know the mindset, and I'm always happy to work within budgets too, because like I never want price to be a barrier to entry for some of this stuff, because again, a lot of it can be super critical. So yeah, and I mean, not that you have to work with me, but I mean, any attorney you work with, I mean, just kind of talk through the cost involved and see what they're able to do from a budget perspective to just kind of help get you where you need to be. I mean, it doesn't hurt to ask, and that also again helps you figure out who's going to be the best fit for you as far as moving forward and helping you protect this stuff. But yeah, I mean, and it is a cost, but it's typically a lot less to take the steps to do it right the first time, rather than having to backpedal and not just pay an attorney, but also pay some patent owner or trademark owner for damages. And yeah, because that is a reality. So better to, it's almost like insurance, if you will. I mean, you pay a little now in hopes that you don't have to pay more later.
Yeah, well, what I'll add to that, I mean, obviously there's the quality component to it, but then there's also the time-saving component to it as well. And if you're starting a business, you only have so many functional hours a week. I mean, if you're doing it on the side, you have a full-time job. Otherwise, you may only have 15, 20 hours a week to work on it. And that's not a lot of time to, do this sort of thing well. So yeah, hiring somebody like Justin, if you can, makes a ton of sense. And the same argument goes for all other types of professionals as well.
Yeah, yeah.
On that note, I'm just curious, at what point should a business owner or somebody with a product come to you? I mean, if we've got an idea on the back of a napkin, should we come to you, or should it be drawn out first?
I mean, so like I'll have the conversation like at any point, and then I mean sometimes a napkin sketch is enough. Other times, I mean, it just depends like on the technology and other things. Like again, if we're talking software, if it's still a high level concept, usually you're going to have to flesh out some of those underlying algorithms. Like you might know like the inputs and the outputs, but like what goes on in the black box in between. And if you haven't gotten those details figured out, like I'll say, well, do a little more development and then come back to me. But like if it's mechanical devices, like sometimes a napkin sketch is enough. And so, I mean, I'm always happy to have the conversations at any point though. So like just, yeah, feel free to reach out whenever. And if I think it's too early, I'll let you know. If I think that you've got enough, then I'll let you know that as well. But yeah, it's no like hard point at which like you're now ready to move forward. It's just it's all going to be case by case, just like anything. It's the typical attorney answer. It depends.
Excuse me. Any other questions? All right. Well, thank you everybody for attending. Thank you very much, Justin, for doing the presentation. Great presentation.